For the nice introductory words, and I'm really happy to continue this topic, which was already started by the previous lecture, and I'm really thankful to the previous lecturer for several technical aspects which were really nicely explained, and I will not need to repeat all this, and I can pay more attention to responsibility issues, and I should say that I will speak about the responsibility of intermediaries, and this responsibility has become very topical on Supreme Court, and also you have noticed that right now in the process we have adoption of a new regulation on uniform digital market. And also for adoption of this regulation, this issue about responsibility of intermediates is one of the key ones. And this also has caused quite much discussion. And also on national level, at least one issue, one case which we have right now. I will not speak about it, but it will be very interesting from the point of view of copyright practice here locally. I know that it refers to responsibility of the internet service provider. I will come back to this, but first of all, but I will not speak in detail since it is still in the process. So the content, although I do not start with terminology normally in these conferences, but right now it is worth mentioning terminology for you to refresh knowledge and to speak about the essence of this, so about responsibility, different aspects of responsibility, and also looking on the point of view of European Union, and also on a local level. And at the end, I would like to speak a little bit about the directive which I mentioned, but only about the Article 13, which is not so successful, or it is successful. The figure is just 13, and so we also are discussing this. As far as I know, today in the Parliament they are going to discuss this issue, and tomorrow they have voting as well. So, about the terminology. In this sphere, the European Commission and also legislator of the EU speak about the online platform, and also we, on daily life, we use this term, online platform. And there is also a notion which is not so often used, is internet intermediary. And so how these two terms should be separated and how they should be understood. So online platform, the common features for both of these platforms. So I have so many here, so I will not cite, but if you look at these, then you see that they are not so legal, and actually separation is not so easy. So this online platform is online platform. It is more they speak here about the significance, economic significance and economic aspect. I think that easier it is when we have examples of online platforms. So here he have some examples. So online advertising platforms, these are the marketplaces and different. For instance, Amazon, we know that such exist. Also different search tools. So different search tools. Starting with Google, for instance. Maybe you use also Yahoo. Then we have Yandex as well, but these are the most popular And we have also social media, which were already mentioned, like Facebook, Twitter, and others. So also creative content selling places, and also different platforms for spreading apps. If we look at the notion of internet intermediary, so this is actually, here we have more of this legal sense. It is a legal category, and this is introduced for defining legal aspect of the this aspect. And the basic principle, basic document is directive on e-commerce, and also Supreme Court uses this for restriction of responsibility. So directive on e-commerce, and it has been adopted here in Latvia with the law on information society law. I would assume that we will not use this law very often, actually, when suing or considering cases. So, and here in this context, one more thing is the service provider of information society, and then we come to the term information society service, and this is defined in our law, and in the law which I mentioned, also in the directive. It is explained. So it is a distance service. So two parties which are not present. So it is a pay service by using telephony equipment, and so by through request of the service receiver. And usually it is a pay service. It is also explained by a European Supreme Court case of Faden, where it says that the Supreme Court explains that this doesn't mean that so this is a payment from users. It is also payment from advertisers, and it could be also, so it is service providing for receiving profit. And therefore, we shouldn't narrow the meaning of this term. So, and as I already mentioned, so there are different types of intermediaries. So it is Article 12 to 14 of the Directive of E-commerce. There are three types of these intermediaries. So I tried to put it into Latvian very precisely. So in the law we do not use this. But here it is, first is access provider, according to Article 12. So maybe you have heard it in English way more. So this is the provider of information services and provides information transmitting in the electronic communication network and ensures access to this network. This is just, for instance, Telecom, when they provide you internet access, they provide this access for you. So they are access providers. The next type of intermediary, so this is a service provider of short-term storing. So this caching, so in Latvian it is very strangely, so it is super fast line. Actually, this doesn't actually convey the meanings about caching, but they have they have suggested also another Latvian word, but this is very, very strange and nobody will use it, I believe. So, but, okay, but these have been just some cases, but normally it is about the access, and the next is about hosting. So this short-term hosting, so the idea is to provide transmitting on information this information should be stored automatically for short term in this intermediary points, so for the signal to be uninterrupted. So this is the idea. So that is the idea. So storage or hosting provider here. So this is the most topical right now. So these are the providers of information services and stores information according to request of the receiver of this. So for this mega upload, for instance, is such a provider, or maybe not, if we look at the responsibility side. So we will speak about this, why it is or it is not. So another example is doubtless it is really a hosting provider. This Dropbox is really a traditional provider of such a service. This is a topic which I will come back again about YouTube. YouTube also stores uploaded video data, video files. Is this really a hosting provider, or it could be referred to this restriction of or limiting of the responsibilities? This is actually a very topical issue right now, but I will have this in the presentation. On the 13th of September, German Supreme Court will have a ruling or judgment, and so it is, and we will see what they will rule about this, but I will tell you in more detail about this a little bit later. So, an online platforms is this comparison. So, so the content for provider and access provider. So we see that this online platform is wider and at the same time more narrow notion than internet intermediary. So Spotify and those where not users are uploading but they are signing contracts with the rights holders, and they ensure the content. They are providers of these services. They are not intermediaries. They are the communication to the public providers, and so we do not dispute this. And then these internet access providers, so they are not online platforms. And then we come to a new term which is coming, which is so. But so it is the draft of the directive is this online content sharing service provider. And right now I will not stop at this notion. I will come to it later when I will speak about the directive and regulation. But as we see, then again we will have a service provider and specific regulation and their activities. And I already mentioned that the Supreme Court, General Court, I'm sorry, they are mentioning that they are basic rights and fundamental rights, but we have to repeat which are the fundamental rights. So we have the rights holder of intellectual rights. So and it is according to EU Charter, Article 17. So the rights to the property. So intellectual property is being protected. Then also regarding the information service providers and this Article 16, the freedom of this business activities, and the end user, individual, which is according to the Article 8 of the EU Charter. So it is protection of personal data, and Article 11, which is the freedom of word and information. So these are the fundamental rights, and In case of intermediary, all these rights should be in balance. And we know that in civil cases, this is not the most practical approach, but when we, with regard to copyright, very quickly we come to the necessity to balance these rights and whether it is in Latvia local court or on national or international level.
When switching going to the substance matter, where we can really find the position of a direct primary liability of internet intermediaries. Or title could be passive legitimization or true and genuine respondent, who would be the respondent in the litigation, as we would use in our common professional terminology. In most cases of copyright, we have discussed the active legitimacy to bring an action, but in case of internet intermediaries, the question usually goes to whom the action should be addressed and submitted against. If we have direct or primary liability, to compare, I would like to mention some simple case. Infringer, or a person, individual, committing the infringement has infringed the copyright of other individual or related rights. These are supporters or co-committers of the infringement, where the aspect of primary intention is very important, and here we should follow the principles applicable under the criminal proceedings law when the supporters and organizers of an offense are caught to liability. And sometimes it is really hard to distinguish among those who are bearing secondary indirect liability. And discussing the secondary liability, we could mention individuals who are intentionally committing some action that is specifically related to the infringement and contributes to the gravity of that infringement, and who bears legal and actual opportunity to prevent that infringement or to minimize it. For instance, internet provider, service provider, if an individual or a legal entity intentionally provides that service against its activity or with intentional participation in the infringement, at that moment they are directly liable for that infringement. But if they are not aware of the specific infringement, which is specifically related to the infringement, why the specificity is mentioned, that the initial intent of such additional infringer or offender, for instance, of that infringer is provided electricity to his or her location, and so on, but this is secondary contribution to the infringement and not a direct contribution to infringement as such, which is directed against some specific copyright. In order to define and detect secondary liability of an individual or legal entity, the diligence or the duty to test, mentioned also by previous speaker, to any merchant and service provider to check and test whether the content he hosts is legal and legitimate. Assessment of secondary liability includes also evaluation whether that duty of diligence has been violated and what happens if the holder of the rights will have paid attention of the internet provider or service provider to the fact of facilitating the infringement against the specific copyright. I would like to mention that secondary liability would not be mixed up with subsidiary liability, which is addressed to the primary infringer or offender. In some cases, it might be more efficient to initiate proceedings against internet intermediaries. For instance, website blocking would be more efficient than finding the true infringers or offenders of that infringement. That is not the liability for the guilt to be proved and to be detected, or whether that specific internet intermediary would be the best option and the best actor or stakeholder to prevent such an infringement. Deliberate action is also introduced as a criterion in order to differentiate between secondary and subsidiary liability in case of the application to protect the rights of the author and to prevent some illegal action against that, as well as repeated offense to be prevented, can be applied irrespective of the blaming guilty one of individuals or legal entities, and internet intermediaries are included here. Applications and claim statements directed and aimed at restoring the original status quo of the copyright can be applied only in the cases of primary liability. Therefore, it is really important to detect and find and conclude what type of liability specific respondent or specific intermediary safe harbor should be assessed as well, whether or quite opposite of that, internet intermediary has lost its safe harbor and should be subject to subsidiary liability in some cases. I would like to draw your attention to the decision made by the Civil Proceedings Panel of the Supreme Court with including the wording that committing infringement is not presumable regarding remedies, and stating or defining the amount of the remedy in case of infringement of copyright is defined according to Article 69 prim of the law on protecting copyright of the Republic of Latvia within the liability restrictions, as it is phrased in the law in the current wording. Only in case of copyright subjects and related rights that could be both exclusive rights, enabling or preventing using the subject of copyright and related rights. We have the decision by the Supreme Court taken only yesterday, on the 10th of September this year, under the case number SKC 10/2018, when the Article 69 prim was not applied, and that decision was made. Regarding liability of internet intermediaries, that could be intermediary liability or secondary liability in most of the cases, both regarding intermediaries and individuals or legal entities holding the primary liability. Direct liability occurs when intermediary is not neutral anymore and he or she has deliberately contributed to the infringement. Assessment or test of neutrality would be facilitated by the recital 42 of the preamble to the e-commerce directive 2000/31/EC, although that exception applies to the access providers and hosting providers, but not short-term hosting provider, but hosting providers in general are excluded, as specific literature states that similar criteria could be applied to the last type of providers of internet intermediaries. Neutrality is stated if actions of intermediaries are technical, passive, and automatic, as they have no information and data. Of course, that could really not apply to platform YouTube, whether they can argument that they have no knowledge or data or intention and information regarding the video files, for instance, which they are storing and hosting. Today, Information Society Directive 2001/29/EC was already mentioned, especially Article 8 and point 3. According to the Application Directive 2004/48/EC and several articles and and paragraphs mentioned herein referring to the same, according to the civil proceedings, law are applied on a temporary basis. Whereas specific regulation on temporary preliminary executive order or injunction, which was not correctly translated and transposed to the national legislation, having a broader coverage in original English language. Therefore, I think that it is really hard to work with the directives of the European Union, which are translated into Latvian by European Translation Department. Paragraph 12 to 15 are applicable to all types of internet intermediaries. Of course, each type of internet intermediaries have their own preconditions for limitation of the liability. Regarding each type of internet intermediaries, there is a reference that the limitation of liability does not affect the opportunities and chances of member state courts or administration institutions to request termination or blocking prevention and termination of that infringement accordance with the legal system of corresponding country, and prohibition to define a general duty to an internet intermediary to manage and to supervise the information that they are broadcasting or storing or hosting according to Article 15.
Total filter.
So this Article 15 is a restriction and to stipulate to intermediary general duty to supervise information what they are transmitting or storing. There are at least two EU General Court judgments which help us to clarify this issue, and there is a balance between the protection of intellectual property rights and for also business activities, and also the rights of the service users regarding protecting their personal data. For instance, the case from 2011, Scarlett Extended, where court stipulates that this balance should be ensured, and there should be this full supervision of communication, and if this balance is not there, then respective activities to be provided. And similar judgment also in the next year's Sabam Netlaw case, also the responsibility of the hosting provider, and also here the state ruled that these fundamental rights should be balanced. So, but looking at the regulation here locally in Latvia with regard to intermediates, we do not have a very successful norm, and it will also make a headache for us how to make it in translation of this. So the article of copyright law, so there's a right to demand that intermediates perform respective events to stop possibilities of users to perform these breaches. And then the next sentence is the intermediary doesn't perform the respective events or measures, then the subject of copyright or its representative has the right to sue against the intermediary. So I understand that first should be activities to stop this breach, and actually, in other words, this is the Article 7 of Article 132 of Civil Process Law should be applied, and if intermediary, which is not the this breaching, and actually is very, very neutral, like internet provider, it is not, actually shouldn't be sued to collect all these case expenses, and it is here if we do not have this previous letter, warning letter like it is in German. So if a claimant is admitting this, then this person has to pay. So we do not have such regulation, but in this only case which we have, we also see this paradox situation here in Latvia. So the respondent admits everything, and now what to do? So the procedure or what to do with the responsibility of intermediary according to the directive of information public. So it is so the member state has to stipulate in its own legislative acts, so we are rather free to determine this. So this requirement, if we bind this together with the previous preconditions which I mentioned, to have this secondary responsibility, so it should be this actual knowledge about the breach. I think that better it is stipulated in the UK law, Copyright Designs and Patents Act, so where the actual knowledge is taken into account, that his service is used for breaching copyright. So here we do not have stress or emphasis on actual knowledge, but we have just stipulations that first the intermediary should be addressed, and then he becomes informed that this and has this actual knowledge that his services is used for breaching copyrights. As I already mentioned, so this is the restrictions of intermediary responsibilities are stipulated by Article 10 of Information Public Service Law, and we also see that we have European General Court judgment in the case SNB React, and so the court has to stipulate whether and what type of intermediate services have been used. And here it was a case about IP address leasing, because actually that was Estonian prejudicial issues. So with regard to access providers' responsibility regarding access providers, these criteria, as you see here, that access provider should be really neutral, should not facilitate information broadcasting. It doesn't choose what should be receiver of the information to be broadcasted, and also it doesn't choose and do not adjust or amend the information to be broadcasted. For access providers, it is a very important judgment of EU General Court in the case UPC Telecable, where the court insisted that and ruled that it should be a balance of fundamental rights, but at the same time admitted that such duty can be stipulated. So this injunction can be made, and the intermediary can choose own measures to be introduced to stop possibility to use his provided services to have access to illegal content, and also will assess whether that these are not a burden to this provider financially. So the question, of course, is whether this is really very strict or very precise judgment. So the very respondent is left with freedom in his hands. So, but if we speak about this, about the same ruling, about this, so this should be just, and at the same should be interpreted also not according to the directive and national law, but it shouldn't be interpretation of directive which are conflicting different EU different principles, general principles like principle of proportionality. And also in one of the next examples we will see a German example. It is alternative approach to this access and to locking access to internet. So the court ruled that these measures should be clear with clear goal and purpose, but I would say that this so strictly targeted actually is that it is precise. So the just translation was not so available translation was not so precise. So it should be with legal content. And at the same time, the question is how to ensure this, because we do not speak about Pirate Bay cases, so it is another case, of course, but we do not speak about cases when only pirate content is available, just only some separate films from the whole content are these illegal or pirate films. So how to ensure this precise goal and to block access only to those illegal films, but not access to the whole site. So the problem issue, which is under all this, how to eliminate the ungrounded access blocking, but it is like. But I would like to speak about such cases as YouTube, for instance, and so which are illegally uploaded content. And you can even only wonder how people invent and how they do this to upload such illegal content. How to ensure that the court shouldn't say that YouTube should be blocked and access to it locked. I would like to invite you to think about the Bundesgerichtshof ruling, two cases in 2015. In both cases, it was against access provider. In one case, it was one of the producers of phonograms, and in one it was a collective using site. So it was a question was about to block access to specific sites. And Supreme Court in Germany ruled that it is possible not only when there are only breaches of intellectual rights, but when legally available objects form a small part of the whole content of the site. But then the question is what to do if it is vice versa, when this illegal content is small part. And so it is about this balanced approach, and so it is also the ruling in case of TV Kabel. So the first is either we should approach the hosting provider or internet intermediary. So it is quite tricky to find every breacher but it is possible to sue hosting provider, as this is one subject. And besides, as federal court is the closest to this breach. Not this access provider, but the hosting provider is closer to this breach because because this access provider just provides access. And Supreme Court of German applied subsidiarity responsibility. So suing the first, which was the closer to breach, and if this is unsuccessful, then we go further, and then we go to access provider. Another issue, which is not so topical here in Latvia, but had been also topical in Germany, and it is rather universal actually in our case, in our situation, about this Wi-Fi or WLAN. So what is responsibility of Wi-Fi operator in cases of breaches of copyright? So for instance, this hotel, what is the hotel's responsibility if you, when you are here, you are uploading some illegal content, so in this case. And then here we have the ruling of European General Court in 2016. This is McFadden, which I already mentioned. They analyzed whether this is information public service. So normally it is paid service. So McFadden was a businessman. He didn't provide Wi-Fi for money, but it was free of charge and without any password to attract clients or customers to his small shop or cafe. I don't remember. And one of the issues was whether we should sue the operator of this local Wi-Fi operator. So it is can he be sued for damages? It was no, and or to ask for this for costs related to this claim. So costs regarding this warning letter and all these can be claimed to cover. And one of the key issues came from Germany, and one of the most actual questions was what about the operator of such network, and should it be password protected, and then you can use this network.
It was related to the identification of duty for a person or individual who will use that password. Of course, if some specific group of users know the password for that WLAN network, then it would be quite hard to identify specific individuals within that group. And that was solved by a ruling that such injunction can be made while assessing alternatives, including complete blocking of the access and several more, but that password protected was considered to be the best or the maximum termination or blocking of business commercial activities, and as far as I understand, that translation of that decision was not very successful either, and defining that secured was secured. The term in English was not password protected, but secured. And here in Latvian language, that word for secure is not very explicit and does not imply the password protection. Regarding hosting providers, I can mention limited liability or limitation of liability according to paragraph 5 of Article 10 of Information Public Services, and provision included therein that in case if hosting provider didn't have factual data or information on illegal actions or information or illegal content provided by the recipient of that service, constructed knowledge as a precondition for request on remedies. But that was not transposed in our legislation. As mentioned before, that factual information or factual data and knowledge or actual knowledge is of great importance in such cases on behalf of hosting provider on illicit or illegal actions of recipient of that service. And if holder of the copyright turns against the hosting provider or any other internet intermediary, so that to enjoy the limitation of liability. In case of file sharing service providers, that would be secondary liability. But I would like to mention that if contributing to the infringement was detected in the format of advertising that service available and so on, really makes the liability, secondary liability, into primary liability as well. Here I would like to mention a liability of hosting provider with decision or ruling made on 26th of April 2017, Filmspieler. These ads-on integrated on the devices, electronic devices produced by third parties, where the links to internet websites were pre-installed or reinstalled. Here, the decisive role will be played by the liability or prejudicial ruling or preliminary ruling in terms of communication to public, that he or she has advertised those multi-environment recorders for downloading audiovisual work and other content protected by copyright without the permission of the holder of such copyright, and if such advertising or communication to the public was provided, prevent the internet intermediary to refer and use that limitation of liability according to the legislation. And going back to returning to the question on whether YouTube can refer to limitation of the liability of hosting provider, the case and ruling made in the Pirate Bay case already mentioned by the previous speaker as well, when the active role or active contribution manifesting itself as indexing, systematization, or providing a system of those torrents and so on. But actually many stakeholders as well as specific literature mentions that whether such a conclusion could be referred to similarities of YouTube as indexing or categorizing of the content under different categories or under different reference systems would also exclude from an option to refer. Perhaps for an elder generation, it is not so important whether hosting provider plays an active role in providing such illegal content, but only facilitation is of great importance as well. Of course, in the case of Pirate Bay, there was another aspect that they intentionally and deliberately facilitated and encouraged to duplicate and to forfeit the illegal content. Here, I must admit that it is hardly possible that in Latvia some hosting provider would commit such illegal actions in advertising and facilitating uploading of illegal content to their server. Apart from that, I would like to mention Stichting Brain in case of the Pirate Bay, or when marketplace operators or providers or browser search engines play an active role, then we cannot refer to a limitation of liability of intermediary, and that active role or active participation or contribution to the infringement is obvious, whether that contains some optimization or advertising or facilitating measures. I've already mentioned that there is decision pending or judgment pending by the German Supreme Court whether YouTube, as well as in Austria, whether YouTube is will be admitted and considered as content provider or hosting provider. The Commercial Court of Vienna has ruled that YouTube is communicating itself and thus is directly liable, against whom the claims on remedies could be initiated against. I'm behind my schedule and I could briefly touch upon the next slides. Perhaps somebody has noted that European Union Parliament has rejected the initiation of the negotiations and talks on the copyright directive, and why such decision by the Parliament of the European Union was made, because the Article 13, proposed Article 13, was the subject of the most acute discussion. And I would like to draw your attention to the mandate for the talks. Usually, such development of such modified proposal, the European Commission also takes an active part. Of course, not, and the opinion of the Parliament of the European Union is not always taken into account by the previously mentioned institution. Therefore, I would like to refer to the latest version, which is not published yet, but approved by the Commission. So regarding Article 13, or the use of protected content provided by online content sharing provider, with a value gap being in the center of the discussion, that disproportionality between the remuneration for the work, creative work, and related rights of that the holder of the rights receives from such platforms like YouTube and similar, and how much these platforms benefit from that. So it's disproportionate distribution of earnings or revenue. Therefore, value gap is discussed, and European legislature has made some certain opinion which has been integrated into the project of the new directive. But one of the challenges consists of the definition of the value gap, how it could be defined, whether it is information public service provider. Those major, or one of the major aims includes storing and providing access, public access to large volumes of the creative work or the subject of related rights that the users have uploaded, and where he organizes or facilitates their distribution aimed at gaining profit. Here we can assess how many works have been uploaded, how many creative works, and then later on are downloaded, and what the proportion of earnings is. Of course, this disputable issue, whether content provider or hosting provider should be applied, whether he or the provider is intermediary or not. So if communication to the public was facilitated, then a primary liability of the intermediary would be implied.
This is done with an idea to stimulate signing contracts and payment to the rights holders. Of course, then this is in this draft directive, it is emphasized that it is important to receive permit from the rights holder. So, and also uploading, so it's not that the user uploads, but the permit for to the platform, so to have these activities of the users. And right now it is an offer to directly stipulate that this is not the restriction of the directive where this is already stipulated, so this safe harbor is not available for these platforms which offer a wide scope of big volume of different work. But at the same time, in the Articles 13.3 stipulated that it is a new safe harbor, stipulating that this online content sharing service provider is not liable if can prove that he has applied best efforts to eliminate the accessibility of respective copyrights or secondary rights objects, and so with respect to the objects which have been identified by the rights holder. So for proportionality, should take into account the size, whether it is the character and size of the services, whether it is micro company or small company. And so European Commission tries to solve this so for content ID, for instance, which YouTube has, it is several tens of millions. So this is a real impossible for startups or new companies to enter the market, and they cannot afford anything like that. So about claims mechanisms, I will not speak about this. So this, regardless of the fact that the reaction against all this is quite huge, so the critical argument was this regulation is like a censorship for internet, like Wikipedia will not be available. At the same time, this regulation actually codifies the judgments of EU General Court and also makes them more precise. So the conclusions I will leave for you just to read, because the slides will be available and you can read my conclusions. Thank you for listening to me. I apologize for taking too much of your time.